Hi, my name is Jessica DeMichiel, and I'm a healthcare attorney with the Coppola Firm. I work a lot with healthcare practices and providers on transitioning practices, labor employment matters, and licensing and regulatory compliance. We're here today to talk a little bit about employment contracts. Now, the very first question you're probably wondering is, should you have an employment contract or give an employment contract to your employees? The answer to that is yes. And then the question is, well, what's going to go in that employment contract? So the first thing I want to talk to you about is the compensation structure. There's a couple different ways that you can write a compensation structure into an employment contract. Some employers are going to choose to have a more vague compensation structure, meaning that they're just going to have a preliminary amount of compensation. Typically, that's the first tier of a salary, any type of bonuses, and then it's going to be set at the discretion of the company thereafter. Typically not as helpful for an employee to know moving forward how much money are they going to make year after year after year. To the contrary, the compensation in an employment contract can be more specific, right? It can set a base salary or a percentage of net collected revenues that gives a minimum floor and a defined criteria by which that provider is going to earn increased compensation or bonuses year after year after year, so that they're aware of what they're going to be making and what they're going to have to do to make more money. But this gives a little bit less flexibility to the employers who are going to have to abide with those contract terms regardless of the overall performance of the practice. The next topic that you're going to have to pay attention to when you're either preparing an employment contract for a provider, or if you're a provider who's looking at an employment contract that you've been given by your practice employer, is what is the responsibility that the provider versus the practice is going to have for the overhead expenses of the practice. And this can be variable depending on, is the provider going to be a partner with the practice or an actual W-2 employee or a 1099? It all will make things a little bit different. So what is overhead to a practice? Overhead to a practice are going to be things such as advertising and marketing, the salaries, benefits, or bonuses of other staff who are non-provider practitioners. They're going to be things like supplies, the technology, the software within the practice. So those are things that the practice and the provider are going to have to come to an agreement on how those things are going to be allocated. Now, there's different ways in an employment contract that these can be allocated. The provider themselves can be responsible for their own provider overhead expenses, meaning the things that they directly need to practice. There can be circumstances by which the provider is required to be responsible for all or a percentage of overhead expenses for either their practice or that office location which they practice in. And then there can be circumstances when a provider could be responsible for all or a certain percentage of the entire company's overhead expenses. And so if you're an employer, typically you're going to want the provider to share in at least a percentage of that or a set amount of that. And if you're an employee, you're going to want it to be fair that you are only paying for things that you utilize in the practice and that you're not somehow on the hook for the entire company's overhead expenses. So this is an important thing to look at. How are the overhead expenses of the practice being shared with the provider? The next thing you want to take a look at if you are an employer that's providing an employment contract, or let's say you're a provider that's getting an employment contract from a potential employer, is, are they giving you upfront bonuses for you to come on, to sign on to the practice? Are they giving you any type of advancement of pay? If this is a partnership level employment contract, are you required to do some type of partnership buy-in to the company? And there's really important factors that you need to look at when you're being offered any of those particular circumstances to come on and be employed by that practice. And if you're the practice that's giving that to your employee provider, you want to know first if you're getting a sign-on bonus or an advancement of pay. Is that a loan, or do you have to work for a set period of time before you're not going to be required to pay that back? Are you going to be given credit for the amount of time that you've been there towards the amount you would have otherwise been required to pay back that amount? If you're a partnership buy-in, there's other important questions that you need to ask, which is, let's say you leave the practice and you decide you don't want to be a partner anymore. Do you have to still pay off that partnership buy-in? Is it an amount that if you do have to pay it back, that the company can accelerate it against you, meaning you're going to have to pay it all back at the one time? And can they take a sign-on bonus or an advancement or a partnership buyout directly from a payroll deduction for any severance or post-termination compensation? These are important things you're going to want to look at. Now, another thing you're going to want to be looking at if you are either providing an employment contract or you're the provider receiving an employment contract are what are the for cause and not for cause termination terms or provisions, meaning how does either the employer or the employee provider give notice when they want to terminate the employment relationship? And is there going to be a waiver of the notice period that needs to be given when there is a termination notice? So sometimes when you give notice of termination, especially usually in not-for-cause situations, you may have to give 30, 60, 90 days notice as the provider. A lot of the times the employment contracts will allow an employer to waive that unilaterally, or the employee and employer to waive that upon mutual agreement. So you're going to want to look at, can that notice period be waived? Are you giving the notice, if it's not for cause in the right manner, whether it's by hand delivery or registered or certified mail? And you want to make sure that you're aware of how you need to give that notice to ensure that you're not waiving any type of separation pay or post-termination compensation or anything of that sort when you do give your notice at the end of the day. And if there is a permittance of a waiver of the notice period, do you still get paid out for that time, especially if the employer can do it unilaterally? So another thing that you need to also be looking at with respect to employment agreements, both from the employer and the employee standpoint, is, are you going to be required to pay, or is the employee provider required to receive different types of compensation at the end and the termination of that employment relationship? So there's different types of pay. There's separation pay. Separation pay is when you pay the employer pays the employee to voluntarily leave the company for services that would have been rendered in the future when the employer has made the decision to usually eliminate the provider's position. So that can be one type of pay. Another type of pay that you'll often find in an employment contract is post-termination compensation. And that's a little bit different than separation pay. Post-termination compensation is typically when the employer will pay the provider for services that were already rendered and that would have been paid out had the provider's employment not ended. So sometimes, for example, you'll see that they'll pay 65% of all amounts that come in through an accounts receivable that are affiliated with that provider for a set period of time. It could be a month, it could be 2 months, but usually there will be a set period of time in the employment contract by which that provider can receive post-termination compensation at the end of their employment. And the last type of pay that you'll typically see at the end of an employment relationship is something called severance pay. Now, severance pay is a little bit different from separation pay and post-termination compensation pay in that the employer is paying the provider to leave their employment and for the provider to waive all legal liabilities that that employee would have had against the employer. And usually severance pay is going to be paid in the setting of, we'll give you a set amount of money, you're going to have to sign a general release that waives all future or past and future claims against that employer at the end of the day. So those are some of the types of pay at the end of an employment relationship you're going to want to be looking for in your employment contracts. An important item that you're definitely going to want to look at in employment contracts is, Are there non-compete provisions or non-solicitation provisions? So non-compete provisions are going to prevent the employee provider from going and working for a new practice for a set period of time within a set radius, and usually from a set location. It could be that particular practice location that they were at. It might be any practice affiliated with your past employer. So it's important to look at non-competes. You want to make sure that they're reasonable at the end of the day. You're also going to want to look at, are there non-solicitation clauses in the employment contract? Non-solicitation clauses are something that are going to prevent the provider from actively seeking their current patients at their current employer from being transferred to a new employer, meaning that you can't go contact your patients once you leave and try to entice them to come over to your new practice. A non-solicitation can also prevent the provider from trying to get employees of their former employer to come with them and work at their new practice. So you want to look at, is there a non-solicitation? What does or does not it prevent you from doing if you decide to leave when your employment is done? And some of the last few items that you're really going to need to look for in an employment contract are there things like non-disclosure or confidentiality clauses? Are there clauses with respect to what your employer can give when they're being called for a reference check, or can they call a new employer and give them information about you? And is there a non-disparagement clause in there that's going to prevent the employer and the employee from saying anything negative about each other? You want to look whether you have or don't have these clauses in your contract, because it's going to prevent things that you can say or things that you can do once you leave that particular employment at the end of the day. If you have any questions about employment contracts, you need help drafting an employment contract, if you want an employment contract reviewed on your behalf, feel free to reach out to us at the Coppola Firm. Thank you.